disposed of as expeditiously as possible. Let's forget the dispose of, that's the duty of the court. The first part, any such review shall be conducted on an urgent basis. What does that mean? It means who conducts the litigation is the parties, and who initiates it is the applicant. So if you unpack that, it simply means that by decree of the legislature, not the court, not the people who draft the rules, the applicant must bring the matter on an urgent basis. So you have here a party that has defied not only Rule 6, for which they seek condonation, but they have also defied Section 21B, and they have not asked for any, not been followed, except these stories about festive seasons and so on. So if you, then they have a double whammy, as they say in colloquial language, where they are unable to satisfy the court on condonation for the reasons which I will not repeat of that my learned friend Mr. Mutau, even on the Arise Africa test. Because on the Arise Africa test, you must, firstly, the delay must be reasonable. Here, we have on their version, they say 29 days. We say it's 100 days, doesn't matter. But the point is that it's excessive, even on the AAR test. It's 4 months. Secondly, you must give a full explanation why there was such a delay. Because they are running away from the real reason, which was the press conference of the 16th of December, they are unable to give a full explanation. Thirdly, you must show that there is no prejudice, or at least the balance of prejudice is demonstrate that there are prospects of success. How on earth can there be prospects of success when you are in the wrong court? When you are here to bring a matter that is, let's even not go to the merits, I'll do that after the break. But just on within the house of preliminary points, there's no prospects of success at all. So, of course, AAR, this court said in AAR and in Glenister, on any test that is conceivable. And I would rest.
We have dealt with that.
Well, when we come back. But let me answer it like this. This is not a Rule 612. There are two legs, a little in due course. No. Assume they have done what we have now all agreed they should have done. Assume that on the 7th of September 2023, my lady, when they received the news of the registration of Umkhonto Wesizwe, they had done what the Act says they must do, and lodged the application, let's be generous, at the end of September. What would have stopped this court from hearing the application in due course? I dare say this court would have sat even before today. So if they had brought the matter as they were duty bound to do, then because you have created that situation, and had you acted as you should have, the matter could have been heard in due course. So they fail on both legs, even if you are generous and use the Rule 612 standard, which we shouldn't be using, because this is a statutory agency. I'm saying, my lady, because we're dealing with statutory agency of a peremptory nature, unlike the agency that we all deal with in the High Court. But I'm prepared, for the sake of progress, to say, let's even use that lower standard of Rule 612. And I say they fail even that lower standard, let alone the higher standard I'm postulating of a statutory test. They even fail the normal Rule 612 because A, it's self-created, B, the matter could have been heard in due course. So it fit with Glenister, Section 21B. Those are our submissions on the agency stroke condonation.
We adjourn until 2? Yes. We adjourn for lunch until 2 p.m.
2 p.m. That's correct.